my collaborators and I, we all felt that we had this instrument out there which offers fantastic opportunities, but everything that people discuss is their legal nature, their soft law character, surrounding private international law questions and so on. But people don't really discuss the substance of the articles. I mean, after all, what matters is, are they a good and useful contract law regime that the parties could and should adopt? And also, once they have been selected, once they govern a transaction, people will wish to know, what do they actually mean? I mean, if they speak of acceptance or if they speak of hardship, what do these terms actually mean? What we know is they certainly do not mean exactly what these terms mean in domestic legal systems. So we're in search of a kind of international autonomous meaning that will apply to these particular provisions. So what we felt was that there was a real need for an article-by-article commentary that would explain these provisions to someone who is faced with them as an arbitrator, as a judge, as a legislator. Now, one of the biggest difficulties in writing this particular commentary is that what you normally do in the commentary, you come up with some plausible explanations of the meaning of the rules that you write your commentary on, and then you enrich this with references to the case law. And in a national jurisdiction, you tend to have plenty of that. Whereas the Unidroit principles are still comparatively rarely used, and more importantly, if there is case law, it's normally awards of arbitral tribunals. And these tend to be confidential. They're not normally published. So there is relatively little case law that's out there and accessible to everyone on which we can draw. So it requires a bit of imagination, and what we do is that we look very much at the rules and then imagine or also look at the role that similar rules play in domestic jurisdictions and the typical problems that arise. And then we try to come up with a solution under the Unidroit principles, not identical to the solutions of national courts, but we use at least the problems as sources of inspiration and try to come up with the correct decision that a tribunal or that a court should find under the Unidroit principles if it ever were faced with such a problem. I think in the preface of the first edition we wrote we came neither to bury nor to praise the PICC, and some people have said this may be a bit disingenuous, because obviously simply by writing on the principles we promote them willy-nilly. And actually one of my colleagues commented and said, well, Unidroit should have given you £1 million for that book, because we're independent. We're not linked to Unidroit, and what you'd find is that many authors who write on the Unidroit principles were involved in the drafting or are working for Unidroit. So in a way they have at least a perceived bias towards praising the Unidroit principles. And we wanted to avoid that. We wanted to adopt a cold-blooded stand and look at them, and if we find a rule is bad, we say so, and we say how it could or should be improved. But at the same time, we tried not to bury them, in the sense that many people actually rail against them because they're just soft law, because they're either too common law biased or too civil law biased, depending on who you talk to. So we try to stay a middle course between effusive praise and strong denigration, and I hope we achieved that.